Fourth Circuit is going to review the cases that have come out of Virginia, one upholding the statute, one striking down the individual mandate, and the Sixth Circuit, which is Michigan and Ohio, is going to fast-track the case that came out of Michigan, which is the Moore case, and that was a case that was upholding the statute. And it's an issue of national importance, and the states have been saying, and rightfully so, that they're doing a lot of work and spending a lot of money to try to implement the law and get ready to implement the law, and they would rather not have to do that if the statute's going to be struck down. There actually have been a number of amicus briefs filed in the district court, which is somewhat unusual. Amicus briefs are friend of the court briefs. They're done by outside parties, people that are, or entities that are not part of the litigation. They're intended to educate and inform the court about issues that are relevant to the decision but may not be the actual legal issues, and can be very helpful. There will be a number of them filed again in the courts of appeals, and then this case will go to the Supreme Court eventually, and there will be a number filed there as well. And they can be really helpful in giving the judge a perspective about the case. For example, if the patient perspective is not being adequately presented by the government, which is often the case because they have other interests, then a brief in support of patients' interests can be really helpful, and especially in this case where we're talking about the individual mandate, whether or not individuals should be required to buy insurance, whether that's going to help or not in terms of getting more coverage, and why there is a problem with coverage now. Those kind of issues would be, I think, really helpful to the court to hear more about and to hear about it from the patient's perspective. I'm relatively confident that the Supreme Court, Courts of Appeals and the Supreme Court will not throw out the entire statute. There's just not enough evidence to do that. It's really hard to predict whether they'll agree that the individual mandate is not supported by the Commerce Clause and is not within the Congress's Commerce Clause powers. Some very conservative constitutional scholars have said that it actually is, and some less conservative, more progressive scholars have said that it's not. So this is one where it's not as much partisan as more of a pure legal issue, and what did Congress and the courts mean as they've interpreted the Commerce Clause over the years, which is the provision that decides what the federal government can do versus what the states can do.